Good evening, class. I'm going to be doing my case briefing on Cooper v. Aaron, which is a landmark case that is a residual or externality of the Brown v. Board of Education. In this case, essentially, school authorities in Arkansas asked the district court to postpone the enacting of the desegregation of schools that was founded in Brown v. Board of Education, or mandated, and referencing difficulties in implementing and providing a desegregated program. The school authorities claimed basically that they had made efforts to do so, but in the course of attempting to make those efforts, have struggled in implementing this. The governor and the legislature of Arkansas very clearly resisted the programs, doing as little as possible essentially to accommodate them, and putting other processes and limitations that were basically hindering the implementation of desegregation impossible in the state. The district court granted a relief to the state of Arkansas, and essentially this moved up to the Supreme Court at that point, where they reevaluated. And so the question really being posed, just for simplification, is should the board provide a postponement for desegregation? Can the state, does the state act within its rights to be able to, or the Court of Appeals within the state act within its rights to be able to postpone a federally mandated law? And in simple, the answer was no. The ruling referenced the 14th Amendment, that no state shall deny any person within jurisdiction of the equal protection laws that were illustrated in the 14th Amendment. Essentially referencing that they did not have the legal authority to deny these students equal access. And in conclusion, the court enforced the desegregation to continue to proceed. And again, they found that within that 14th Amendment, the justification to process this. My personal takeaway from this is that, we as a society, with state laws and federal laws and how to implement and hierarchy, how do we enforce these laws? Where do we derive this authority from for the federal government to institute these laws against the state? It's a tale as old as time in a lot of ways, because the Civil War and things we see today with gay marriage and with legalization of marijuana, state and federal authority has been pushed back and forth. A state could legalize marijuana in one state, but as we saw in California, we'd have federal agents enforcing those laws only until a few years ago, until the state actually legalized it, and the federal authority recognized that legalization. So, again, where does the federal government derive the authority, and how can they enforce it is a great question. I think I'm taking away from this. As we move forward in the course, I will definitely be asking myself that question, and where politics and the interaction with these federal rulings, where the enforceability of them, if you don't have the legislature or the executive branch enforcing these rulings, is there is there actual power there in order to do that? And I think the answer is no. A little bit scary, as we are in a highly politicized climate, and it's grateful that, at least from my recollection, we have not seen that kind of divisive politics and enforcement of Supreme Court rulings. But I guess the Brown v. Board of Education and the forcing of desegregation in schools is one of the primary examples of one we've seen. So, again, interesting court case on the back of a even more interesting court case in Brown v. Board of Education, and a direct externality of that. So, yep. Thank you so much for your time.